My name is Krystal Gomez. I'm an immigration attorney practicing here in Texas. I respectfully oppose HB 256. The INA doesn't limit familial relationships to only those that are biological family units. Familial relationships for the purposes of immigration law can be established due to step-parent relationships, adoption, which obviously would not provide positive DNA results. This bill also represents an alarming expansion of government power. It authorizes an invasive DNA collection based merely on an agent's reason to believe that a person is misrepresenting a familial relationship without requiring a warrant, probable cause, or judicial oversight. We should be deeply skeptical of any policy that allows government agents to collect biological samples from people who haven't been charged with any crime. HB 256 also creates concerning precedent. Once we authorize warrantless DNA collection in this context, what prevents future expansions of such power? Today, it's border DNA testing, but tomorrow it could be other contexts where Texans' privacy is compromised. From a fiscal standpoint, implementing this program would require significant taxpayer funding for equipment, training, and handling of biological materials. These resources would be better directed back to Texans' pocketbooks. This isn't about being soft on border security. It's about being faithful to constitutional principles and wary of government overreach. We should be focusing on targeted enforcement against actual traffickers rather than subjecting families to invasive biological testing without due process protections. Thank you.
Thank you for that testimony. Members or questions of this witness? Seeing none. Thank you for being here, Sarah Cruz. We show you Sarah Cruz. You're testifying on behalf of ACLU Texas and against the bill. Is that correct?
Yes, sir.
Please proceed.
Chairman Keene and committee, thank you for the opportunity to provide testimony. My name is Sarah Cruz, and I am here on behalf of the ACLU of Texas to oppose HB 256. HB 256 greatly expands the Texas Department of Public Safety's collection of our permanent identifying information without appropriate guardrails. HB 256 is also an unnecessary proposal because it duplicates existing efforts by the federal government, raises serious privacy and civil liberties concerns, and DPS also has a backlog for tests like DNA analysis and likely does not have the capacity for this proposal. While HB 256 states that samples will be destroyed and the DPS may not maintain a database of the results, this information will still need to be prepared and provided to DHS. DNA contains personal information such as health and genetic predispositions and familial connections, heightening the risk of misuse or unauthorized access to facilitate the deportation of whole families, including U.S. citizens, as many families are mixed status. This could also place individuals who are fleeing persecution at risk in the event of unauthorized access to collected information. It was only a couple of years ago that DPS experienced a data breach that leaked the information of more than 115,000 Texans. These efforts would also be duplicative of existing DHS operations. U.S. Customs and Border Protection is required by law to collect DNA samples from non-citizens, excluding lawful permanent residents detained under the authority of the U.S. CBP also assumed responsibility in September 2021 for conducting DNA testing to determine if an adult claiming to be a biological parent of a child is true. Lastly, this will unnecessarily strain limited DPS resources. As of late last year, DPS was still reportedly dealing with their own backlogs in DNA testing. Moreover, during a February 26 appropriations hearing, DPS Director Martin reported challenges in recruiting and retaining non-commissioned employees, with a 25% turnover rates in parts of the state and only 2 places in the whole state where there's 24/7 coverage by troopers. We urge this committee to focus on public safety concerns and not on forcing state law enforcement to engage even further.
Members or questions of this witness? Seeing none. Thank you all for being here. Before you leave, Mr. Mills, and you may not be able to answer this question. Is there anything that prohibits DPS from entering into this contract or adopting a policy now? I mean, do you have to have legislative directive to do this if DPS chose to go down this road?
I don't believe there's anything that prohibits us from contacting our federal partners and going into a contract.
Because you've done it in the past, is that correct?
Not from a lab DNA space, but I do believe that there's relationships between the two agencies, yes.
Okay. That's what members, are further questions of any of these witnesses? Thank you so much.
Thank you
for being here. All right. Chair calls Priscilla Lugo, Michelle